Hi, I'm Greg Dell with Dell Disability Lawyers, joined by attorney Rachel Alters, and we're going to talk about one of Rachel's recently resolved cases against Hartford. And Rachel, Hartford's always a battle, but this was one that you were able to have another success for a client. So tell us a little bit about the background of the case, and let's also provide some tips for people to take away from this that will help them with their Hartford disability case.
Sure. So this is a client of ours. She happens to be a general duty nurse, so she has a medium duty job, which means that she lifts very heavy weight. It's very physical. And she had to stop working due to a back injury she had. She has radiculopathy, degenerative disc disease, and a bunch of issues with her back. And then she also had knee issues where she required knee surgery. And she went out of work, and Hartford refused to pay her long-term disability claim, completely denied the entire thing, and said that she was fine to go back to work and lift patients who were over 200 pounds, and general duty nurses have to be on their feet all day. And so she came to us and said, her doctors have taken her out of work. She's not able to do even part-time perform her job as a general duty nurse. So we took on her appeal and filed it for her, and we were successful.
So let's go into a little bit of the background of the case and the history. What was their basis for denying her, and did they ever pay her at all?
Never paid her at all. And they did a peer review. They never sent her for an IME. They never had their doctors even speak to her. But what they did was they just reviewed the medical records, and they felt that it was their opinion. They disagreed with her treating physicians, and they said that there wasn't enough objective evidence to show that her back injuries, her lower back pain, her knee injury, and her knee pain was enough to keep her out of work. And they said, we disagree. We think you could do your job. And she was up in arms. She was very upset when she called me and said, I really need your help because not only can I not work, I don't have any income, and they're not paying me. And she was.
This is a more general question.
Yeah.
From your experience, I know you've handled over 1,000 Hartford claims. How often do you see Hartford initially deny someone where they're only relying on a paper review or peer review, like you just said?
95% of the time.
And is that allowed under ERISA regulations, that they don't have to examine the claimant? They can just hire someone to say, look at these medical records and tell us if the person's disabled?
Yeah, it is allowed, and unfortunately ERISA allows that, and the administrative judges can look at that and say, well, they did have a doctor who was qualified to review the records, gave opinions, but the policies allow them to do an independent medical evaluation, and they oftentimes choose not to do them, most likely because they're costly, or maybe they're going to show that these claimants are really disabled, so they choose to do just the peer review.
What challenges did you see in this particular denial, and how did you overcome them so that you were able to win the appeal for your client?
Well, the issue we had was, we only had her physician's medical records and what he was saying, his word. So we had her undergo a functional capacity evaluation, which, was a 3 or 4 hour evaluation that tested what her physical abilities were. How long could she sit and stand and lift and push and pull and climb? And it's a full report that documents these abilities. So we had that done, and that result showed up that she was actually less than sedentary, that she couldn't even do sedentary work on a full-time basis. So we had that report sent to her treating physician, and he reviewed that, and then along with that, he wrote his own report with his documentation, with her MRI reports, and she had injections, she'd taken a lot of pain medicine. The pain medicine actually was causing her cognitive issues, so she couldn't take the pain medication any longer because she wasn't able to think clearly. So there were just so many factors that prevented her from being able to work, besides just the pain that created the need for the medication, and then she had the inability to walk for long distances because of her knee. So we worked with her physician. He reviewed her functional capacity evaluation, and then he wrote a report, and that was basically what it took for us to get her decision overturned.
Now, initially you said in the denial that there was not enough objective evidence, but what did Hartford think was missing?
They weren't specific on, because she had had MRIs, she had had injections in her back, she had had a lot of objective evidence, but sometimes that's just the tag phrase that they use, and they have their peer review doctors look at it and say, well, our doctors don't think that her, subjective complaints correlate with the objective proof in the file, and that's often what they do, and they use that to deny the claim. Most of the time, these peer review physicians are just saying what Hartford wants them and pays them to say.
Right, that's super sad.
It is.
What do you think, looking back at this claim, and as a tip for someone who's on claim right now, could do to help avoid a denial the same way in which your client got denied?
I mean, sometimes they're unavoidable because at times they're just going to deny no matter how much objective medical proof is in the file.
Because Hartford's going to do the wrong thing.
Exactly. But what I always tell my clients is to make sure they're treating with their doctors on a regular basis. They're following medical advice from the doctors. A lot of times if the doctors recommend something and then the patients don't follow it, such as going to physical therapy or doing whatever's done, they often use that against them. But I say just make sure that they're telling their doctors everything that's going on with them, because if it's not documented in the records, what's going to happen is they're just going to assume that it doesn't exist. So, you know, a lot of people, especially doctors and nurses, they tend to be, you know, superheroes. They don't want to complain because they're in the medical field and it's not something that they, you know, they see a lot. So I always tell my clients, make sure you tell your doctors everything going on, what you're not able to do, what you can do, and make sure they're documenting it. That's very important.
So now that you won the appeal, you were in what's called the own occupation definition of disability, correct? Which means that your client as a nurse had to be unable to perform the substantial material duties of her occupation as a nurse.
Correct.
That definition usually only lasts for 2 years, 24 months. Mm-hmm. So you're now still within that 24-month period, correct?
Yeah.
And then that's going to change to unable to perform the duties of any gainful occupation, which could be any occupation based upon her experience, education, and training, or it may say that it's a job that would pay her 60% of what she used to earn. So that time period is going to come up quickly, and it's assumed that your client may not be able to go back to another type of job. Sure. So what do you suggest to your client to do to prepare for this change in definition, which is coming probably relatively soon?
Yeah, the conversation needs to be had with her treating physicians because, you know, as we discussed earlier, her job before was a medium duty job, which is lifting lots of weight, where it's going to transfer and change to whether she can sit at a desk 40 hours a week, maybe review medical records and be, you know, or nurse case manager, or somebody, you know, somebody who's not doing the heavy lifting. So she needs to speak with her doctor about her ability to sit for long periods and work at a computer and all of those things so that the doctor will be documenting those things. Now, fortunate for her, when she had the functional capacity evaluation done recently, it showed that she was less than sedentary, meaning that the physical therapist didn't even believe she could handle a sedentary job at this point. So we may want to redo that functional capacity evaluation down the road. But it's really important just that she's very vocal with her doctors so that if the peer review doctor calls her doctor and says, do you think she's capable of sedentary work? The doctor will say absolutely not, because she can't sit for extended periods of time due to her pain in her lower back.
And what kind of requirements will Hartford have from a paperwork standpoint moving forward now that you won the appeal?
Right, they're going to want updated claimant statements, so they're going to want to know, you know, what her hobbies are, what she does on a daily basis, maybe what her educational background and experience was, so that they can prepare themselves for the change in definition. They also may want updated attending physician statements from her doctor, and of course updated medical records. That's always very important. So I always tell my clients, just because you got approved doesn't mean you stop seeing the doctor. Make sure you go on a regular basis, so when they request those records, there's actually records to be had.
And like in this case where your client has a knee disorder and a back disorder, and you just mentioned a regular basis, what does that mean? How often should she be going to the doctor now?
Right. I mean, it's not black and white, but I usually tell them every 3 to 6 months, never wait 6 months to go. I like to see my clients and the doctor every few months, just so, you know, the insurance companies will look at it as if you're not treating, at least every 6 months or every few months, you must be fine, even though it's not necessarily the case. And some of my clients will say to me, well, there's nothing more that the doctors can do for me. I say, I don't care. I want you in that office. I want you to tell them everything going on so that there's documentation. So when it comes time for the review, there's plenty of evidence that you're still disabled.
I would always say a minimum 3 months, just because that only equates to 4 times a year. But I also understand for claimants that it's expensive. It's not free to go to the doctor. Right. So that's another expense. And they say, like they do, Rachel, why am I going? Because there's nothing they can do for me. Right. And I don't want to, if I am taking pain meds, they refill my prescription. If I'm not, yeah, they can give me pain meds. I've already had injections. I don't want more pain meds. It's just, this is why it's a chronic debilitating condition. So, well, great job on this case, and hopefully your client will continue to stay on claim, and as you help her transition through from the ONOC to the ENEOC definition of disability, there's continued work to be done there, obviously. And even when she does hopefully transition, never let your guard down with these claims, because Hartford's always gunning for you at any given moment to try to deny the claim. And it is a month-to-month evaluation, even though they may not ask for something every month. So if you're someone with a Hartford claim, feel free to call myself, Rachel, any of our disability lawyers. No matter where you live in the country, we're available to assist you, and we look forward to the opportunity to help you. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process, and when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now, at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search, plus we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now, we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.